Good morning. My name is Bobby Link from GalloTracking.com. Today, we're going to be joining a committee meeting, specifically Senator Brad Hoylman's Senate Judiciary Committee in the New York State Senate. They're going to be considering a bill 5473D. This is the so-called Engel reform bill. This is the most significant foreclosure proposed legislation in over a decade. It would essentially say that if your mortgage foreclosure is dismissed for a procedural technicality, like a failure to properly send out 90-day notices, which is a significant issue in light of the recent Kessler decision, if you don't commence your second case within that 6-year period and you're not otherwise saved by a now limited savings statute, you're going to be out of luck and you're not going to be able to recommence the case. So I want to join the meeting today, let you get a flavor for some of the questions that are asked. In some cases, you'll see Republicans on the committee press back with questions. In other cases, you'll see the bill just sail through without a whole lot of discussion. This will be an interesting one, and I'm following it because it is of significant interest, to our listeners and viewers. So I'm going to bring in the video.
Is Senate Print 5473D by Senator Sanders.
This is the Sanders bill.
Sorry, Senator, that last bill was reported to the floor.
I'm sorry.
Yep, no worries.
Yes, the bill is reported to the floor. That was Senate Print 5472.
And this is the staffer.
Thank you. Next item is Senate Print 5473D by Senator Sanders.
Act to amend the Real Property Actions and Proceedings Law, the General Obligations Law, and the Civil Practice Law and Rules in relation to the rights of parties involved in actions commenced upon real property related instruments.
Are there any questions or comments? I see Senator Palumbo. Thank you, Senator.
Thank you, Chairman. I guess I'll just generally make some comments. I may have a question or so, but this is in response to my understanding, based upon the sponsor's memo as well. This is in response to a Court of Appeals case whereby it's somewhat of a technical thing, but where banks can start a foreclosure action, or they can accelerate the loan and then ultimately work something out with the borrower and voluntarily discontinue that by way of a settlement. What this bill will do will ultimately, I guess to an extent, sabotage the fact that these banks can work something out with the homeowner, because in the event that there is that there's a second default, they may have a statute of limitations issue, and this basically bars them from accelerating the loan, quote unquote, again, by saying that the statute of limitations is run. And in that particular case, in this Freedom Mortgage against Engel, Judge DiFiore wrote a very comprehensive and well-reasoned decision. And I want to just read from the decision very briefly, so that it can clarify in everyone's head how this is actually completely counterintuitive to what it intends to do. Because it's going to force banks to now just simply foreclose and take your home. Because during the pendency of a foreclosure action, obviously, the homeowner still lives in their home. And then when they work out a modification, and the bank is in the business of money. I know they're villains, typically seen by many of my colleagues, because they're big, bad banks, but they don't want to own homes. So as you may have seen, that these modifications are at 2%, even less on some occasions. They don't make any money. They just want people to stay in their home and pay their bill. So this is from the decision directly that Judge DiFiore authored. This case just demonstrates why acceleration should not be deemed to occur absent an overt unequivocal act. Note holders should be free to accurately inform borrowers of their default, the steps required for a cure, and the practical consequences if the borrower fails to act without running the risk of being deemed to have taken the drastic step of accelerating the loan. Even in the event of a continuing default, default notices provide an opportunity for pre-acceleration negotiation, giving both parties the breathing room to discuss loan modification or otherwise devise a plan to help the borrower achieve payment currency without diminishing the note holder's time to commence an action to foreclose on the real property, which should be a last resort. And a little bit further down, Practically, the note holder's act of revocation, also referred to as de-acceleration, returns the parties to their pre-acceleration rights and obligations, reinstating the borrower's right to repay any arrears and resume satisfaction of the loan over time via installments. That is, removing the obligation to immediately repay the total outstanding balance due on the loan, and provides borrowers a renewed opportunity to remain in their homes despite a prior default. So, thus following a deceleration, a payment default could give rise to an action on the note to collect missed installments, in an action with the 6-year statute of limitations that runs on each installment from the date it's due. So I know it's a little in the weeds, and this is somewhat of a complex issue, but I think we need to be clear in our minds that, of course, I see in the sponsor's memo, it was a long discussion of how, there's predatory lending, and there's all kinds of issues that this seeks to remedy, which I believe it doesn't. And I understand that the sponsor's counsel may have even represented a homeowner in the case that I'm referencing. So I'm sure they're quite familiar with it. But at the end of the day, how is this helpful when a borrower now, the banks you may actually cancel a few mortgages and some people will get a free home, which is going to be a wonderful hooray for everyone, right? The banks will then be smart enough to say, you know what, you default, we're going to start a foreclosure action, we're going to seek it to the end, we're going to take your home and we're going to kick you into the street and not even try and modify this loan, because we're not going to run the risk of losing all this money. So the fact of the matter is, it may be a gotcha moment on 2 or 3 occasions, but this is a terrible bill for people who have less money. This will benefit people who can afford their home. This will hurt people in lower income communities, quite frankly. I think the ones that it seeks to help. This is, again, it's a terrible idea. It also strikes other aspects of the savings clause where you can refile an action after time, even if a statute of limitation would otherwise have been, would have otherwise expired if you had an action pending. Again, it's a very technical bill, but the bottom line is this will essentially prohibit banks from working out a mortgage after 6 years from your default. In the event that there is a subsequent default, they'll lose the opportunity to sue and foreclose on the loan and take the collateral. So this is going to kick people into the street. It's a terrible idea, and I urge my colleagues to vote no. Thank you.
So Senator
Thank
Palumbo,
you.
pleading with the
Senator
Democratic
Boyle.
colleagues
Yes, thank you,
that
Mr.
the
Chairman.
bill
I'd
is
just like
going to have
associate
unintended
myself with Senator
consequences.
Palumbo's remarks.
This is
I
Senator
agree with
Phil
everything he
Boyle.
just said. This is actually going to make it more difficult to negotiate and to come up with an agreement on a payment plan for someone who's having a difficult time. Those of us involved with this area, these things go on for months and years. Easily. They don't get resolved overnight with banks and lenders and lendees. So it's going to make it more difficult for those who really need to help in these times. And also, a lot of New York State banks are going to be like, well, I'm out of here. We put a lot of regulations on them, and this is just one that could be the straw that broke the camel's back for several of them. So I urge my colleagues to vote against it for these very reasons. It's got the best interest, in heart. I understand what the effort that you're trying to put in and the goal, but this is not the way to go to do it. Thank you, Chairman.
Thank you, Senator Boyle. Senator Myrie.
Thank you, Chair Hoylman.
This is Democratic Senator
great
Myrie
respect
from
for
Brooklyn.
my colleagues, Senators Boyle and Palumbo, but have to respectfully disagree and speak up in support of this bill. And not only representing an area that has been ravaged by predatory lending. We have, I represent Crown Heights, an incredibly diverse community that has been hit hard by foreclosure and too many people being taken advantage of. But the notion that our banks are hurting or have to go through hurdles to take someone out of their home is, I think, a proposition that I'm very happy being associated with because someone's home, there's nothing greater than that, and nothing greater than that security. And I think that this introduces stability in the system where a statute of limitations means a statute of limitations. It does not allow for the reset of this that I think provides the advantage to those financing the home as opposed to the homeowners. And so I think that this, contrary to what I think we've heard, actually helps with stability. But ultimately, I believe this bill is going to keep people in their homes. that is something that we should be in the job of doing. And particularly for homeowners where this is their only source of wealth. These are people that don't have other sources of wealth, but their home is their greatest asset. I think, it's important for this legislature to be supporting people keeping that and having the ability to maintain that in the future. So I appreciate the
Be
chair
getting
bringing
free
this,
homes. It should
before
be
the
noted
committee,
that
and
Brooklyn
I'm hopeful that this will
is
get to the floor.
where a lot of the
Thank you.
real estate investors are
Thank you,
from,
Senator Myrie.
who've been
Senator Thomas.
sponsoring
I
this
would like
legislation,
to
going
first,
around trying
thank
to
sponsor of the bill, Senator
rally
Sanders,
support around the
for
bill.
his work on this, and the staff and all the advocates. This is a major bill, and it
This
needs
is,
to be addressed.
Senator
The situation
Thomas,
with the Engel decision.
Democrat.
Now, I want to agree with Senator Myrie and also respectfully disagree with Senators Boyle and Palumbo. Since 2009, lenders are required by the CPLR 3408 to negotiate in good faith at court supervised mandatory settlement conferences to achieve foreclosure avoiding solutions. The law does not permit them to avoid this obligation, and there's no explanation that's offered for the assertion that the application of long-standing statute of limitation principles recently abrogated by the Engel decision will force lenders to violate their legal obligations to negotiate in good faith. Or once they have accelerated a loan, it is not possible to exhaust the loss mitigation process within the 6-year limitation period. I think they're overthinking this. I think this is a great bill, and it should definitely go through this committee to the floor for a vote, because this is going to help both banks and the homeowners. Thank you.
Thank you, Senator Thomas. Senator Gennardis.
Senator Gennardis, also from
Woman,
Brooklyn, Democrat.
I also want to agree with Senators Myrie and Thomas. I've had a number of my constituents who actually practice in this field, have been meeting with me multiple times over the last year, basically since the Engel decision came out, to explain just the negative impact and the consequences of the court's decision. And so the fact that we were able to right this wrong, I think, is really significant. And I just think it's also important to point out that we are overriding a prior court decision and restoring the law to what it was prior to February of last
And
year.
that's of course not
Many
correct.
parts
This
of
bill
so
goes a lot further than what the pre-Engel law was. Gennardis also mentioning, I think it's interesting, the significant lobbying effort happening in Brooklyn over this.
Last year. So the notion that this is going to be a radical departure is really just wrong, because we are going back the way things were, and I think for that reason alone, it's an important bill, and as well as for all the other additional statutory protections that have been included that Senator Thomas alluded to and Senator Myrie alluded to. I think it's a good bill. It's taken a long time to get to this point. There have been multiple versions back and forth. I know between Senator Thomas's bill and Senator Sanders' bill, and there's been a lot of negotiations and conversations, and there's broad-based support for the premise that this will actually help keep people in their homes and not let them lose their homes because of a surprise tactic by a bank, which does not notify someone that they have restarted or reset a statute of limitations that they may or may not even know exists in the first place. So it's for all those reasons that I vote in the affirmative. Thank you.
Thank you, Senator Gennardis. Senator Bailey.
Thank you, Mr. Chairman.
Senator
Not to
Bailey,
belabor the point, I just wanted to make sure I
co-chairman
echo the
from the
sentiments of
Bronx,
The three colleagues
Democrat.
preceding me, and in terms of just hearing from practitioners in this area, and specifically my community, the Northeast Bronx, ravaged by the foreclosure crisis, very similar to Southeast Queens, where Senator Sanders, the sponsor of this bill, hails from. We have lost scores of generational wealth that we quite frankly will not get back because of foreclosures, because of the actions of certain banks, and because of the predatory actions of certain banks. Let me be very clear. And for all the reasons that have been more eloquently than I could stated by my colleagues. And I think Senator Gennardis hit the nail on the head when he talked about essentially this is the separation of powers. The legislature is exerting its ability to look at something that we believe that was incorrectly decided, review it accordingly, and make more changes via the legislature. So I think this is the legislative process as it has been designed, and I applaud my colleague for doing this. Thank you, Mr. Chairman, for bringing this bill to the committee, and I will be voting in the affirmative.
Thank you, Senator Bailey. Any further questions or comments? Seeing none, is there, Senator O'Mara, did you have something to say?
No, I'll be voting in negative.
Okay, thank you. Is there a motion to move the bill? Senator Bailey, seconded by Senator Myrie. All those in favor, say aye.
Aye.
Any opposed, in addition to Senator O'Mara, Senator Boyle, and Senator Palumbo? Any without recommendation? The bill is reported to the floor. Thank you for that good conversation. The next.
Okay, so we saw that bill pass on a party line vote. Democrats, of course, voting in favor, Republicans against. The most substantive opposition questions came from Republican Anthony Palumbo, who said, I guess trying to persuade the more liberal-minded Democrats on the committee that this bill causes problems. Said that it's going to hamper settlement negotiations. That was not a particularly persuasive line of argument, and I'm not. I guess I agree to some extent, but I don't feel like that's the primary reason to oppose the bill. In any way, this will go to the floor. I'm sure the Senate has enough votes to approve the bill. The next question is whether or not there's enough support in the Assembly, where this same bill is sponsored by Helene Weinstein, who is the chairman of the Finance Committee, the powerful Finance Committee, and obviously a persuasive voice in the Assembly. So there is a good chance of this bill moving forward. And we've seen by the questions and the failure to rally opposition around this issue that the technical nature makes it very difficult for the senators who might be inclined to oppose the legislation to really articulate why this is more than just a return to the law prior to the Engel decision. Again, this is much more than that. It would severely limit the ability of banks, once a case is dismissed without prejudice for failure to comply with a technical requirement, it'll prevent you from bringing a new case pursuant to CPLR 205, the saving statute. You can only do that one time, and you got to be able to do it within 6 months and serve the complaint within that time frame. The end result, particularly in light of Kessler, is going to be significant dismissals with prejudice and a number of primarily investors, short sale negotiators, investors who prey on borrowers in default, ask them to transfer title, knowing they can litigate the statute of limitations issue. They'll go through that statute of limitations litigation process, hire a local attorney, sometimes step in the shoes of the defendant, and try to leverage those, that litigation into getting a free house. So that's what we're going to see. That's why this push is coming from Brooklyn, and you're seeing Senators Gennardis and Myrie so enthusiastically in support of the bill. We'll see what the next step is, and we'll keep you informed. Thank you so much.